All rise. Tribunal now in session. President Robinson, the Honorable Tribunal members Newcomb and Carmody presiding.
Please be seated.
The case before the court of the government of Canada versus the government of the United States. The applicant and the respondent are each allocated 40 minutes to present their pleadings. We'll now hear from the first applicant.
Oh, excuse me 1 second. I might, as the president, if I might make one or two initial comments, if that's all right. First of all, it would be helpful, I think, if each side were to introduce themselves and their team. We'll introduce ourselves. My name is Davis Robinson, and on my right is Kai Carmody, and on my left, Richard Newcomb. We're very, very honored to be here with you all, so I'd ask if each of you would first introduce your team. And the applicant first, please.
Hi, my name is Emma Gardner, and this is Jason Bart, and we're representing the applicant, Canada.
Very good, welcome.
Hi, my name is Samantha Cernan, with Coalition for Foreign Parliament, and we're representing the government of the United States.
All right, well, fine, thank you very much. You should assume that your arbitrators have read your memorials, and we have a fairly high degree of familiarity with the facts and the legal positions that you all are taking. The main objective of an arbitral body such as this is to assure that there is due process and that each of the parties has an equal opportunity to present its case. So if there's ever any kind of an issue on that score, I would be grateful if you would inform the tribunal, please, because that is what our goal is to make sure that there is due process and that each side has an equal opportunity. And with that, we invite the applicant to proceed. And as I understand it, there's 40 minutes aside. Are you going to seek rebuttal? If I understand it, you can reserve up to 5 minutes.
Yes, Mr. President, we would like to reserve 2 minutes for rebuttal.
You'd like to reserve 2 minutes for rebuttal, and then I assume you would like to also reserve the same amount of time for rebuttal. All right, so they'll be up to 38 minutes. If I understand it, we have the option to allow up to an additional 10 minutes for one side, and if we do that, I would assume that we would look fairly and equitably for similar requests from the other side in the event that we were to do that. So with that, please go forward.
Good afternoon. Mr. President, Your Excellencies, and may it please the Court. My name is Emma Gardner, and today I will be speaking about how the United States violated international law in Oregon's refusal to issue a marriage license to Sam Chandra and Bill Hader. My co-agent will be speaking discussing how the United States violated international law in blocking the sale of a boat named the Oscar Wilde. Would Your Excellencies care for a brief recitation of the facts?
I don't think we need that. No, that's all right. We would be happy if you wish not to do that.
Thank you.
Thank you so much.
Your Excellencies, this case is about family. The United States has failed to equally protect Bill and Sam's family, and has also wrongfully interfered with Sam's lawful attempt to save his family member's life.
Pardon me, this is a proceeding about the law, and so I hope that you will get into the law as to the foundation for whatever it is that you are arguing, please.
Yes, Your Excellency, Canada submits that both of these actions are in violation of the United States' international obligations. To begin with, Oregon's refusal to issue a marriage license to Sam Chandra and Bill Hader was in violation of the United States' international obligations under the International Covenant on Civil and Political Rights. First, this action violated Article 23's right to marry and to found a family in conjunction with Article 2's guarantee of equal protection of ICCPR rights. Second, this action...
Pardon me again, Counsel. Are you arguing that this international convention is a self-executing convention, or did it require federal implementing legislation?
Your Excellency, the United States has characterized this convention as a non-self-executing convention. However, that would mean that there is no recourse within the United States for individuals to enforce the treaty internally. That would not preclude this court from finding the United States in violation of international law before this court today.
Well, if it is a non-self-executing, international agreement, then what is the role of the 10th Amendment of the Constitution of the United States, reserving to the states those powers not specifically granted to the federal government?
Your Excellency, Canada does not believe that the 10th Amendment would preclude a finding in violation of international law in this case, as any action of Oregon is attributable to the United States under the international laws on state responsibility. Therefore, the United States is responsible under international law. Specifically, in this court's case on the application of the Convention on the Prevention and Punishment of Genocide, this court stated that it is a cornerstone of the law on state responsibility that the action of any state organ is attributable to that state in international law. In that case, this court also stated that it believes that the International Law Commission's Article 4 on state responsibility is a reflection of customary international law. This article specifically states that any legislative act taken by a state organ, whether it is a part of the central government or of a territorial unit, is attributable to that state in international law.
Now, Counsel, you have cited the ICCPR, and you have asserted that the United States is in violation of the ICCPR because of the failure to recognize the right of these two men to marry. Where does that right come from? There's some conflicting jurisprudence here, is there not?
Yes, Your Excellency, Canada is advancing two alternative arguments under the ICCPR. First, under Article 23 and Article 2, and also under Article 26. Beginning first with Article 23, perhaps Your Excellency is referring to the Joslin versus New Zealand case before the Human Rights Committee. However, this case can be distinguished from the present case for two reasons. First, the applicants in that case, or the plaintiffs in that case, did not advance an argument that Article 3, Paragraph 2 should be read as a single and indivisible right to marry and to found a family, as Canada is arguing today. Second, with regard to the argument under Article 26, the concurring opinion in Joslin stated that Joslin should not be read as a blanket rule that differential treatment of married couples and same-sex couples would never violate Article 26, noting that future cases must also satisfy the reasonable and objective criteria test, which Canada will show today the United States cannot pass. Turning to Article 23 of the ICCPR, Canada submits that by recognizing Bill and Sam's right to a family, but denying them the right to marry, the United States has violated Article 23, Paragraph 2 of the ICCPR. That this right should be read as a single and indivisible right is supported by the ordinary meaning of the text, as it does not say the right to marry and the right to found a family, or the rights to marry and to found a family.
Excuse me, Counsel. In the United States, there are some states that have recognized the right to marry. There are some states that have not. But furthermore, if I understand it, the party states to this convention, a vast majority of the party states, they do not recognize the right of same-sex marriage. Now, with regard to Canada itself, how many of your provinces officially recognize a right to same-sex marriage?
Your Excellency, same-sex marriage was legalized in Canada across the entire country in 2003. With regards to...
And that was by federal law?
Yes, Your Excellency. It was a Canadian Supreme Court case. With regards to your concern regarding the number of states that have not legalized same-sex marriage, Canada is not arguing for a finding before this court today that all parties that have not legalized same-sex marriage are in violation of the treaty. Canada is arguing that once a state has recognized a group of individuals as a family under its state and practice, it is entitled to protection under Article 23. This is consistent with the Human Rights Committee general comment regarding Article 23, in which it stated that although no standard definition of family can be given, as you mentioned, it may vary considerably from country to country. Once a state has recognized a group of individuals as a family under its practice and legislation, they are entitled to protection under Article 23.
Counsel, your position implicitly rests on the idea that this reference to man and woman can be read as covering both the situation of same-sex and opposite-sex marriages. But your friends will argue, or may argue, that in fact there's a distinction in the wording in this particular provision versus all other provisions in the ICCPR, and that this distinction in wording has to have some meaning. That, taken together with the Jocelyn decision, would suggest that there was an intent to limit this to heterosexual unions. So how do you justify departing from that?
Your Excellency, first, as the South African Supreme Court noted in Ministry of Home Affairs versus Fourie, an alternative explanation for the use of men and women in this provision was to exclude child marriages from the ICCPR. Furthermore, although Canada would also like to note that the ordinary meaning of this treaty does not preclude same-sex marriage, as it does not say the right of men and women to marry each other, or the right of one man and one woman to marry.
But that's the way in which the Jocelyn decision went, was it not?
Your Excellency, it did say, the Jocelyn opinion said that this provision that marriage had been universally understood to include only opposite-sex couples, which was true at the time of the Jocelyn decision. However, since then, that would not be how this provision is universally understood, as 16 countries have since legalized same-sex marriage. Furthermore, Canada submits that the definition of family is important in this case, as Oregon has recognized Bill and Sam as entitled to a family in enacting the Family Fairness Act, specifically stating that Oregon has a strong interest in promoting stable and long-lasting families, including those of same-sex couples.
Pardon the interruption again, but a lot of this case may depend upon the burden of proof and on which issue lies the burden of proof with which party. Would you please explain for us in this area that you were arguing where lies the burden of proof and on what issues, please?
Certainly, Your Excellency. With regards to Article 26, which Canada will discuss later, it would be the United States' burden to provide a reasonable and objective criteria justifying the differential treatment based on sexual orientation. With regards to Article 23...
Oh, pardon me on that now. Under the Lotus decision of long ago, unless there is a binding conventional obligation, or there is a customary international law rule that is in effect, what isn't specifically prohibited is then regarded as a general matter as being permitted. Are you arguing that the state of the customary international law is such at the moment that same-sex marriage is required as a matter of international law, that is, the right to same-sex marriage has now reached that level of state practice and acceptance that it should be regarded as a governing norm of international law?
Mr. President, Canada is not advancing an argument with regard to customary international law before this court today. Canada is
So it's based only on the convention?
Yes, Your Excellency, which the United States is a party to. Therefore, if this court does interpret this treaty...
Well, it is a party to, but the United States, upon ratification, did also issue an understanding. And that understanding, I assume, was as a result of the Constitution and the Bill of Rights. And as you may know, the United States, after the Second World War, we went through the Bricker Amendment controversy as to how far the Senate of the United States, in ratifying treaties, may upset the apple cart of the U.S. Constitution. And of course, the general theory is that the ratification of a treaty may not reverse any provision of the Constitution.
Yes, Your Excellency. However, Canada is not arguing that this treaty would reverse any article of the Constitution. I would like to... When the United States ratified this treaty, it made 5 reservations, 5 understandings, and 1 declaration. Is Mr. President referring to the understanding that was filed with regard to Article 26 and Article 2?
Yes.
Canada would submit that this article did not limit the United States' obligations to the United States Constitution, which is supported by comparing the language of this understanding to the language of the 3rd reservation. The 3rd reservation filed by the United States referred to the obligations of cruel and unusual punishment under Article 7 and explicitly stated that it was limiting its obligations to cruel and unusual punishment as defined by the 5th and 14th Amendment. This was also termed as an understanding, or as a reservation, pardon. However, the understanding filed by the United States did not explicitly mention equal protection under the 5th and 14th Amendment when referring to Article 2 and 26, indicating that the United States did not intend to limit its obligations. Turning to Article 2, referring earlier to why this treaty should be interpreted to include same-sex marriage under Article 23, Canada submits that precluding same-sex marriage in this case would result in a violation of Article 2. Therefore, the object and purpose and an interpretation in good faith would require including same-sex marriage in this case due to Oregon's recognition of family. Article 2 specifically states that each state party undertakes to respect and to ensure the rights recognized in the ICCPR without distinction of any kind based on categories such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Canada submits that sexual orientation is entitled to protection under Article 2, as well as under Article 26, which Canada will address shortly, under either the category of sex or other status.
Do you have any support for the position that this is an other status?
Yes, Your Excellency. First, the ordinary meaning of this term indicates that the list is meant to be non-exclusive, as it begins with the term such as and ends with other status. Furthermore, this court said in its case of the dispute regarding navigational and other rights that a term in a treaty should be presumed to have an evolving meaning when a general term is used and the treaty is of continuing duration. Therefore, even if sexual orientation was not within the intention of the parties at the time the treaty was enacted, it could be interpreted to include sexual orientation in this case. Canada would also ask that this court look to other human rights treaties to interpret the meaning of other status, much as it did in its case of the land, island, and maritime frontier disputes. Specifically, there are similar non-discrimination clauses ending in other status in the Convention on the Rights of a Child, the European Convention on Human Rights, and the International Convention on Economic and Social Rights that have all been interpreted to include sexual orientation.
Well, let me ask, if I might, counsel, there is the notion of intertemporal law, and the convention, I believe, am I right, that came into effect 1966? And one would have thought that if sexual orientation was included within the definition of the term other status as a sort of evolutionary development, that there would be a record that such is the case. And I'm not aware that there is very extensive reporting of any such evolutionary development.
Your Excellency, I see my time is about to expire. May I answer your question?
Yes,
to briefly
please.
Conclude? Your Excellency, the ICCPR has been interpreted to include discrimination based on sexual orientation by the HRC. However, the HRC found that sexual orientation fell within the definition of sex discrimination. That is the only interpretation of the ICCPR specifically regarding the recognition of sexual orientation. In conclusion, Canada respectfully requests that this court find that the United States' actions were in violation of Article 23's right to marry and found a family in conjunction with Article 2's guarantee of equal protection of ICCPR rights. Furthermore, this action is also in violation of Article 26 of the ICCPR. Thank you.
Thank you very much, counsel.
And now we're from the second applicant.
Yes, you may proceed.
Good afternoon, Mr. President, Your Excellencies, and may it please the Court. My name is Jason Bart, and I represent Canada in the matter before you today. The United States acted in violation of 1 Security Council resolution and 2 international agreements when it blocked the sale of the Oscar Wilde. First, Security Council Resolution 1373, and second, the Terrorist Financing Convention as supplemented by the Inter-American Convention Against Terrorism. Your Excellencies, turning first to Security Council Resolution 1373. This court, in its Kosovo advisory opinion from 2010, provided a method for interpreting Security Council resolutions. The court in that case noted that the Vienna Convention cautioned against exclusively using the Vienna Convention on the law of treaties to interpret Security Council resolutions, but required reference to other factors, including other Security Council resolutions on the same issue, as well as the statements of members of the Security Council that were made at the time the resolution was adopted. The Security Council adopted Resolution 1373 under Chapter 7 of the UN Charter, and thus its mandatory language constitutes a binding obligation on all UN member states, including both the United States and Canada.
Well, now, Council, 1373, as I recall, resulted from the 9/11 horror, and are you at all arguing that the 9/11 events have anything to do with piracy?
No, Mr. President. If this court were to find that the NLF is a pirate group or Moses Andrew is a pirate, then that would fall within the scope of perhaps of the executive order and of the Security Council Resolution 1844. I believe the executive order is 13356. But that executive order only forbids ransom payments to groups or entities that are listed in the annex of the executive order. And the compromise is clear that neither the NLF, nor SAM, nor Moses Andrew is listed in that annex. Similarly, Resolution 1844 only forbids ransom payments to groups or terrorist groups or individuals that are listed as sanctioned by the 1844 committee. They have to be designated by that committee for the ransom payment to be forbidden. And the compromise, again, does not indicate that the NLF, SAM, or Mr. Andrew was ever listed by the Sanctions Committee by the 1844 Sanctions Committee. There are two provisions of Resolution 1373, Your Excellencies, that the United States would likely use to justify blocking the sale of the Oscar Wilde. Specifically, paragraphs 1D and 1C of that resolution. Paragraph 1D requires all UN member states to prohibit their nationals or persons and entities within their territory from making funds available to terrorist groups. Similarly, paragraph 1C requires all UN member states to freeze without delay the economic resources of those who commit terrorist acts and of those persons and entities acting on their behalf or at their direction. Canada contends that facially, the elements of 1373 1D are not met in this case, because when Sam would have paid the ransom, would have sold the ship to pay the ransom, he was a Canadian citizen and in Canadian territory, not a United States citizen and not in the United States territory.
Councillor, if I could ask a question, doesn't the authority with which the United States is acting refer back to a 1996 statute, the Effective Death Penalty Act, and regulations promulgated thereafter? So you're citing a UN resolution that was enacted 5 or 6 years after the original authority for the FTO designation. Can you comment on that?
Well, Your Excellency, with respect to the United States domestic law, Canada would contend that the United States domestic law would only apply where the United States has jurisdiction, and that the United States domestic law would not apply to Sam, who is a Canadian citizen and located within Canadian territory when the sale of the ship would have occurred.
Well, if that's the case, why has Canada not enacted or utilized the Foreign Extraterritorial Measures Act, as it has done in the past in cases involving Cuba, to interfere with the extraterritorial or purported extraterritorial application of this law?
Your Excellency, Canada can simply can't comment on what Canada might have done under that. However, Canada would note that the issue before the court specifically is whether or not OFAC's action in this case, preventing the sale of the Oscar Wilde, to pay a ransom, to bring back the love of Sam's life, bring him back home safely, whether that would violate international laws against terrorist financing. Your Excellencies, turning now to, even if this court finds that 1373 1D does not apply, or that facially the elements were met, Canada submits that 1373 1C's freezing obligation is still not met in this case, in light of other Security Council resolutions on the same topic, as well as statements of members of the Security Council made at the time the resolution was adopted, as noted, as permitted and required by this court's Kosovo opinion.
Well, so you're arguing, if I understand it, that 1373, which was directed at a horrific terrorist atrocity, is intended to also include run-of-the-mill piracy.
No, Mr. President, not.
I'm saying that because you regard this not as a run-of-the-mill act of piracy, but as an act of terrorism. But how do you make the leap from one to the other? the crime of piracy has been around since the Roman Empire, if not before. 9/11 is super generous, and let's hope that it remains so. So how do you get us from A to Z when we're dealing with ransom in a world where lots of ransom has been paid to lots of pirates in the last 8, 9, or 10 years? How does one fit in with the other?
To address your concerns, Mr. President, if this court were to determine that the NLF is a pirate group, or that Moses Andrew is not a terrorist, then the ransom would be perfectly permitted. As noted, the only types of ransoms that were forbidden are to those groups that are actually listed on either in the annex to the executive order or designated by the 1844 committee. And the compromise is clear that none of these entities were listed or individuals were listed on those lists. And so Canada is merely contending that, assuming the most unfavorable set of facts to Canada, that the NLF is a terrorist group, and say the ransom would get to the NLF, Canada still contends that even if in that most unfavorable set of circumstances, the ransom payment would still be permitted by international law, by Security Council resolutions, and by the Terrorist Financing Convention. Turning to other Security Council resolutions on the same issue, resolution...
Pardon me, and you would base that on the fact that the NLF is not a specially designated national under the executive order?
Yes, Mr. President.
So that you would refer to the United States law as the foundation for your conclusion under the international law?
No, Mr. President. We would be referring to the Security Council resolutions and the binding obligations of the United States and Canada pursuant to the Terrorist Financing Convention and the Inter-American Convention Against Terrorism.
But hasn't the United States implemented through the specially designated national program its requirements under the UN Security Council Resolution 1373 by the issuance of Executive Order 13364? And designated terrorist organizations under that group are covered. You're referring to a designation under a whole separate authority. Can you distinguish those?
Yes, Your Excellency. The United States or Canada would note that the specially designated terrorist list generally refers to entities that are listed by the Treasury Department and refer to Al-Qaeda and other designated entities. And that the FTO list is a separate list denoted by the State Department. And that the executive order relating to piracy only forbids ransom payments to entities that are listed in that annex, and that none of these groups are designated as being in that annex.
How do you anticipate the U.S. will enforce this if it's outside the jurisdiction of the United States? The vessel is in Canada, not in the U.S.
Your Excellency, Canada would contend that if Canada has exclusive jurisdiction in this matter, then it's simply outside the scope of the United States' power to enforce the freezing obligation as it applies to Sam, the Canadian citizen who is within Canadian territory when the act of terrorist financing would have occurred. Your Excellencies, turning now to Security Council Resolution 2133, which is the latest in the 1373 family of resolutions. It's the first UN Security Council resolution devoted specifically to terrorist hostage taking, and it imposes no new legal obligations because it was not adopted pursuant to Chapter 7 of the UN Charter. But under this Court's Kosovo opinion, it does provide some interpretive guidance. Paragraph 1 of that resolution reaffirmed the obligations under 1373 generally, and paragraph 10 specifically addressed the private payment of ransoms. And while it did not explicitly permit private individuals to pay ransoms to terrorists, it certainly did not prohibit the practice. The exact language calls upon member states to encourage private sector partners to adopt or to follow relevant guidelines and good practices for preventing and responding to terrorist kidnappings without paying ransoms. Your Excellencies, this is further made clear by the statements of representatives of the Security Council made at the time the resolution was adopted, which is also recommended as an interpretive tool in this Court's Kosovo opinion. Mr. Oyarzabal, who's the Argentine representative to the Security Council, expressly stated that measures to freeze funds that are the product of hostage taking should not undermine the possible payment of ransom for hostages. In addition,
Excuse me. Now, the Oscar Wilde is a U.S. flag vessel. As I understand it, the incidents occurred in the high seas. It was in the exclusive economic zone, which is still the high seas. Are you arguing that the United States would not have any jurisdiction with regard to the Oscar Wilde in that situation that it found itself in when Mr. Hiker was kidnapped?
no, Mr. President. Canada is not asserting that that Canada alone would have exclusive jurisdiction. But if this court were to so find, then that would be dispositive in the matter. Canada would submit.
So you're not arguing the way that Canada does so frequently that the executive order and whatever else OFAC has done in its regulations, you're not saying that that is an unlawful extraterritorial reach of U.S. law?
It very well could be, Mr. President, and if this court were to so find, that would be dispositive. But even if this court were not to so find, then within the exercise of concurrent jurisdiction, the United States would have to exercise its jurisdiction in accordance with its obligations under international law and within the scope of the international agreements to which it is a party. And Canada would submit that the United States is acting outside the scope of the agreements to which it is a party.
How would you address for us, please, the burden of proof issue? What are the issues that you were arguing that require us to find the burden of proof and to see whether it has been satisfied or not?
Your Excellency, Canada is merely asserting, as far as the burden of proof goes, that the United States is acting outside the scope of its international legal obligations, and advancing three alternative arguments in that regard. If this court were to so find that the United States acted in contravention of the scope of its agreements under one of those three alternative arguments, that would be able to be dispositive in showing that the United States had violated international law, satisfying Canada.
So the burden of proof is on your shoulders as far as this issue is concerned.
Yes, Mr. President.
Yes, thank you.
Article 8, turning now to Article 8 of the Terrorist Financing Convention. So if this court were to determine that 1373 does not apply, then the United States' actions would still be in violation of Article 8 of the Terrorist Financing Convention, which provides that parties cannot freeze property unless that property has been allocated for the purpose of committing the offenses set forth in Article 2. In Article 2 of the Terrorist Financing Convention requires reference to every word in that provision, and thus requires that any act of terrorist financing be done both willfully and unlawfully. And Canada contends that because SAM's actions were not done willfully and unlawfully within the meaning of Article 2, they're outside the scope of the freezing obligation of Article 8. Your Excellencies, SAM's actions in this case were not willful because they were compelled by Moses Andrews' ransom threat. To interpret the terms of a treaty that are not defined in the treaty itself, this court has looked to the principles of interpretation in the Vienna Convention on the Law of Treaties, and has looked specifically to Black's Law Dictionary to interpret a term, to find the ordinary meaning of a term not defined in the treaty itself, in this court's oil platforms case. This court, Black's Law Dictionary, defines willful as, in common parlance, used in the sense of intentional, as distinguished from accidental or involuntary. Similarly, Black's Law Dictionary defines compel as to cause or bring about by force, threats, or overwhelming pressure. Canada contends that Moses Andrews' threat contained in the email to visit the worst consequences upon Moses Andrew represents a compelled act that makes Sam's decision to pay the ransom not a fully free choice, not a fully willful act, and thus outside the scope of Article 2 and Article 8. Essentially, the NLF, or Moses Andrew and his threat, held up a knife to Sam's throat and said, pay $5 million soon to this bank in Tuvalu. Otherwise, the love of your life will suffer the worst consequences. Similarly, the United States' own Supreme Court, in its 2010 Holder versus Humanitarian Law Project, noted that willful requires more than a mere knowledge that funds would be used by a terrorist group, but instead requires a specific intent or purpose to fund a terrorist group.
Counsel, is the Holder decision a decision that binds this court?
No, Your Excellency, it's not. Canada would submit that this court could consider the Holder decision under Article 38 of this court's statute.
Right.
Turning now to...
So it would be, in your submission then, that it would be simply persuasive, is that?
Yes, Your Excellency, it would be persuasive or a subsidiary means of, subsidiary source of international law. Yes. Turning now to why Sam's actions were not unlawful. The ordinary meaning of unlawful, as defined by Black's Law Dictionary, is that which is contrary to law. Article 32 of the Vienna Convention authorizes reference to the travaux to interpret, to confirm a term, to confirm an ordinary meaning of the term. And it recommended the travaux to the Terrorist Financing Convention, recommended retaining the word unlawfully to exempt from the scope of the draft convention legitimate activities, what it called legitimate activities, like ransom payments.
Well, is unlawful in that context solely unlawful in terms of the international law, or might it be unlawful under also domestic law?
Your Excellency, or Mr. President, Canada would contend that it would be outside the scope of unlawful as defined in the treaty, because the travaux addresses what the drafters thought the treaty was considering. But it's important to note that the final version of the Terrorist Financing Convention, as ratified by both the United States and Canada, retained the word unlawful, and Canada submits retained it with that understanding.
Well, no, wait a minute, Counsel. You're sort of dancing around things here a little bit. This business of lawfulness is an open question. You're not indicating to us whether or not lawful is to be determined by the law of the jurisdiction where the money was received, or the law of the jurisdiction where the money was to be paid, by the law of the payer's jurisdiction, or the recipient's jurisdiction, or some sort of vague synthesis of all of these under international law. What does the convention have to say about unlawful, and by whose law is it to be considered lawful or unlawful?
I see that my time is running short, Your Excellencies. May I answer your questions and then
Yes,
briefly
please
conclude?
do.
So, Your Excellency, turning to your question, unlawful, even if this court were to look at unlawful within the law of the United States, the laws of the United States actually permit the payment of ransom. 18 U.S.C. 1202, short title ransom money, only forbids receiving, possessing, or disposing of a ransom that's actually been delivered, and doesn't forbid actually paying the ransom. Similarly, the 2013 United States government policy on ransom payments that governs the entire executive, including the Treasury and state, noted explicitly that it permitted the payment of ransoms, families of hostages to elect to pay ransoms to a terrorist group. And that's why, in conclusion, Your Excellencies, Canada would respectfully request this court find that the United States acted in violation of international law when it blocked the sale of the Oscar Wilde, because the United States actions were not in accordance with its own domestic legal principles relating to unlawfully. And so, for that reason, Canada would respectfully request that this court find that when the United States blocked the sale of the Oscar Wilde, it violated international law. Thank you.
All right, thank you very much, counsel. Thank you. All right, we are now ready for the respondent. We welcome you. Please proceed.
Mr. President, Your Excellencies, and may it please the Court, my name is Samantha Serna, and I'm representing the government of the United States of America. My co-agent, Lauren Tollerman, will speak to the terrorism issue, and I will speak to the same-sex marriage rights issue. The United States respectfully requests that this Court find that the decision of the state of Oregon not to grant same-sex marriage licenses is not in violation of international law pursuant to the following two submissions. First, there's no explicit right to same-sex marriage under relevant treaties to which the U.S. is party, and that these relevant conventions and provisions within those treaties cannot be read to create such a right. And secondly, that increased recognition and protection of individuals on the basis of sexual orientation is insufficient to create a customary right of general practice. First and foremost, the relevant provision or convention to the matter at hand is the ICCPR, as the opposing agent indicated. Passed in 1966, 166 countries roughly have adopted it, to which the US and Canada are both party to. In order for the court to find for the Canadian government, it has to accept the Human Rights Committee's interpretation of the word sex under Articles 2 and 26 to find that it encompasses sexual orientation as a protected ground. And that decision is the Tunin v. Australia decision of 1994. In that case,
if the United States felt that this convention somehow denied the states of the United States the right to decide whether to allow same-sex marriage or not to allow same-sex marriage, why would the United States not have had a special understanding, a special declaration, a special reservation on this subject when it ratified this convention?
Mr. President, the travaux and preparatory documents related to the specific Article 23 that grants the right to marry indicates that the idea of same-sex marriage was not contemplated, as does the language in contrast to other language used throughout the ICCPR. The preparatory documents demonstrate the phrase husband and wife was used throughout the drafting process of Article 23. And the decision that was ultimately decided was men and women. It's the position of the United States that this indicates there was no contemplation of same-sex marriage, right? And so what the court would have to do in this instance to find for the Canadian government is to read that right within the right to marry and Articles 2 and 26 pursuant to the Tunin decision.
But there would have to adopt the evolutionary theory that somehow the law over the decades does evolve and that there have been changes over the last 50 years, 45 years, or whatever, that have made something that was not even considered at the time in a broad manner somehow had evolved into a new situation, and that indeed that now the convention covered any sort of discrimination even at the state level.
Well, that's certainly the position of the Canadian government. The United States would point the court to the Joslin v. New Zealand Committee's decision. That is the only case that specifically is on point to the right of right to marriage under Article 23, and discusses what is a state, a party to the ICCPR, what their obligation is. And they interpreted men and women within the language within Article 23 to mean that there's a requirement and an obligation that states recognize heterosexual couples. And it's the position of the United States that that's the language that's required and which binds the United States to this decision.
But why did the convention in its final form not use husband and wife?
There's nothing that indicates why specifically it was used. The United States position is that that's indicative of how the contemplation of same-sex marriage was not included within the ratification of that process, specifically when that language is used in contrast to other languages and other words used throughout the provisions within the treaty that use individuals, persons, rather than men and wife, and that this supports a language argument that men and women is included to mean heterosexual couples, that is the interpretation that was intended at the time of the ratification, and that's the interpretation to which the United States should be bound. Going back to the Tunin decision, there are several issues that the United States proposes as to why this should not be binding upon the court in finding that sexual orientation is included within the word sex. First, there are narrow facts of that case. Australia did not defend its statute. It actually deferred to the committee's decision on the interpretation of sexual orientation and whether protection on the basis of sexual orientation was included under the phrase other grounds, to which opposing agent pointed to as the basis of finding this right. The committee actually did not find the language to include sexual orientation protection under the other status phrase. It found it within the word sex. In that case, what was at issue was a sodomy statute. It was not related to the right to marry and what a state's obligation was under that right. It actually found a violation under Article 17, which was related to the right to privacy. And it made this determination as to a protected ground of sexual orientation being found in Articles 2 and 26 at the very end of its decision, after it had found that Australia was in violation of its obligation under the ICCPR, without much explanation as to its reasoning. Finally, the United States proposes that this decision is a subsidiary source of law related to a different right. It was the right to freedom of discrimination because the sodomy laws were at issue in that case. Here, we're dealing with a state's affirmative obligation under the right to marry, and the United States points the court to the decision in Joslin, which is the only Human Rights Committee decision that deals with a state's obligation under Article 23, right to marry.
How much of the U.S. case is dependent upon the state of customary international law as distinguished from the proper interpretation of the convention?
It's both, Your Honor, and the first argument is that there is no language to support a right under convention law within the ICCPR, and that given a widely accepted definition of customary international law, the Canadian government still hasn't established, it wasn't their position, but even if that were a position that there is a customary law, there isn't anything to indicate that as well.
So you are arguing that on this issue, the burden of proof is also with Canada?
Yes, Mr. President. They would have to establish that there is a right under the ICCPR in which the United States is in violation. We point to the court to the Joslin decision that is the only one that has determined what a state's obligation is under Article 23. And within that interpretation of the right to same-sex marriage, what would have to be required if sexual orientation were adopted and found that that would be an enumerated right? That right, if found, which the United States is arguing is not within the ICCPR, it would still require a piecing together of other provisions within the ICCPR. Article 31 of the Vienna Convention governs interpretation of treaties. It requires a good faith reading and an ordinary meaning and treatment to the terms in light of the object and purpose of the treaty.
Yes, but arguably, counsel, Article 2 of the ICCPR does militate in favor of a sort of large and liberal interpretation of equality-based rights, does it not?
Yes, but that's also related to enumerated grounds. And so the first, in order to find for Canada, it would have to argue that they would have to accept that sexual orientation is a ground found within the ICCPR. Which
yes, but it says, with respect, it says includes, does it not?
Includes the language.
The grounds that are enumerated, does it not? And it also says other status, does it not?
Absolutely.
So it could well, sexual orientation could well be fit in one of those categories, could it not?
It could, but it would still require that this court piece that sexual orientation protection with the right to marry. And as the court or the committee within Joslin decided that the obligation under Article 23 doesn't require a recognition of same-sex marriage couples.
Well, but now wait a minute. Joslin is the decision from what year?
2002.
Okay, and we're now in 2014. That's 12 years ago. We've also had a number of major jurisdictions, including the United States, that have at some level approved of same-sex marriage, have they not?
Yes.
So I think Mr. President's question to you about the evolutionary status of the law in this respect has to be given some considered view, does it not?
Absolutely, and I think this speaks to the second part of my argument, that even though there's been increased recognition and protection on the basis of sexual orientation, this still isn't sufficient to establish a general practice or customary law to the recognition and the right to same-sex marriage. What's at issue here is what is the United States' obligation under the ICCPR?
Well, where do we get some litmus test for measuring what is custom?
Yes. So language, Article 38 within the International Court of Justice finds that customary international law results from a general and consistent practice of states following by them from a sense of legal obligation. This is generally broken up into two elements. The first is that there be a general and consistent practice. The Continental Shelf case indicates that practice should be both extensive and virtually uniform in the sense of the provision that is invoked. and should moreover have occurred in such a way to show a general recognition that a rule of law and legal obligation is involved. Here, only 16 states have adopted some form of recognition. It's hardly indicative of a general and consistent practice that the right to same-sex marriage requires legal recognition of that right.
So were you arguing that for purposes of the evolutionary argument under the convention, that the same standard should be applied for that supposed evolution as would be needed for a customary international law norm to come into effect? Is the test the same, or are they different?
You would have to point to some source of international law to find that the United States is in violation of it. The position of the Canadian government is that you point to the ICCPR. Even demonstrating that the United States demonstrating that there is no such provision, there is no explicit right, and that it's not persuasive upon this court the tune-in decision to find that sexual rotation is a protected right, you would still have to find that that provision related to equal protection of Articles 2 and 26 relate to the right to marry, that those two hinges and that creates a right. Even in that regard, if that's still in the alternative, you still have to demonstrate that there's some basis to find that states are obligated to recognize legal marriage, and there just isn't a basis for that. There is definitely a generalized movement towards finding for international human rights within sexual orientation and finding a freedom from discrimination on the basis of sexual orientation. But the issue at hand is, what is the United States' obligation under international law, both within the Convention and customary international law? Having established that the Convention doesn't require state recognition of same-sex marriage, it would, the alternative is to look to customary international law, to which the U.S. Submits that there is no such law within that right. I'd like to address some of opposing agents' arguments. First and foremost, the Joslin distinction. The Canadian position is that it doesn't argue a family right, and that the concurring opinion states that the decision should not be read in such a way that it falls outside the protection of Article 26. It's the position of the United States government that the decision in that case, the instance, was not related to the right to marry. That is only the New Zealand decision, or excuse me, the Joslin decision, that has focused on the right to marry, and that should be the persuasive authority because the HRC's familiarity with the Convention, with the ICCPR, as well as its mandate to make sure that state governments are in compliance with their obligations under the ICCPR. Secondly, the Canadian put forth the argument that recognition that the state of Oregon has established in this case means that same-sex couples are entitled to protection under Article 26. In looking at the language of Article 26, there is no violation when read in light of the Family Fairness Act and what was enacted. While the compromise does not include the entire statutes and the language of the statute, what is included demonstrates that Article 26 and the enumerated grounds under Article 26 were not violated. The statute actually grants rights. It provides for rights that are similar to what are the rights granted to heterosexual couples. Whereas this is distinguished from instances the HRC has found that states are in violation of Article 26, such as sodomy laws, laws that necessarily and affirmatively discriminate on the basis of enumerated grounds.
So you're arguing that there should, in our mind, be no distinction between being named a domestic partner and being named a husband or wife?
We would ask the court to look to the decision, to look to the language of the article, to interpret and to see that what has been interpreted by the Human Rights Committee and what is explicit within the treaty is an obligation to recognize heterosexual couples, and that the language and the way that it is so contrasted to other provisions supports that reading, that the contemplated understanding of the phrase men and women was for heterosexual couples. That, in combination with the HRC's decision to read the obligation in such a way, is persuasive, and that's the obligation that the United States has. And so what Canada seeks to do is find that the United States is in violation of international law for a right that isn't explicit, for a right that isn't found in customary international law, and require that this court not only adopt an interpretation that was found by the HRC in a decision that was not discussing the right to marry, and combine that reading with the right to marry and the right to equal protection under the law to establish that it's in violation of international law.
Would your conclusions be different, hypothetically, if the Supreme Court had found the Oregon law unconstitutional?
It would not be different. There's a distinction that's necessary in that regard, because this case and this issue is related to the United States international obligation that's separate and apart from municipal law and what would be required internally. International custom establishes that countries have their sovereignty to govern their country in the way that they most see fit. And so what at issue is here is, what is the United States obligation? And it is the position of the United States that given that there is no explicit right to same-sex marriage under the international treaty law, and that relevant conventions that cannot be read for the right to create that law, and finally, that increased recognition and protection of individuals on the basis of sexual orientation doesn't establish a general practice or customary law, such that we respectfully request that this court find it is not in violation of international law. If there are no more questions, we conclude. Thank you.
All right, thank you very much. Yes, please go ahead.